Yeah, no, thanks for being here, Langston.
Yeah.
I'll go ahead and get us started. So my name is Colleen Shaw. I'm the Vice President for the McLean County Reentry Council, and I am also the Outreach Manager at Bloomington Public Library. I'm standing in today for Toy Beasley, who's our President, and he is at a Reentry Summit. He might be able to join us a little bit later, but I would like to welcome you all today to the council meeting. We are very excited to hear from the court. We have Mr. Is it Scanlon with us?
Correct.
Scanlon. Great. Who's the trial court administrator. He's going to be doing a overview on the Safety Act and its implications on the court system. It's possible Judge Yoder might be able to join us in a little while. Currently, he is preoccupied with some business, but we're happy to have Mr. Scanlon here. As you may know, Illinois was the first to abolish the cash bail system as a condition of pretrial release through the new law. So we are grateful for the chance to hear about that and how it's impacted the courts since September when it was signed into law. We're also going to be hearing today from Dr. Frank Beck, who is, I believe, or maybe was, or still is the director of the Stevenson Center for Community and Economic Development at ISU.
Yeah, that's right. Starting in July, I'll be a regular faculty member again.
Okay, great. And is that in sociology and anthropology?
That's right. But this work is going to keep going, and I'm going to ask permission to keep using the Stevenson Center name. But the work with the courts and the data will continue.
Great. Yeah. So the part of the mission, as Mr. Beck mentioned, Dr. Beck mentioned, of the Stevenson Center is to provide community-based research. So he will be providing us with some important statistical information specifically on the impacts of the population at our local McLean County Jail. So we look forward to hearing from him on that. So we are thankful to have them both with us today. Before we go through with introductions, I just want to thank everyone that attended the McLean County Reentry Fair on May 4th. It was a fantastic event. We had a wonderful turnout. I stopped counting at 200 people. We had over 200 Excellent. People there. It was wonderful. We were able to provide support, food, resources for people that attended. It was just a beautiful day. We were able to hear from people that were just as impacted and are now doing great things in our community, and just hear about their example and influence. So I really appreciate everybody that was able to come to that. So with that, we're going to go ahead and start with introductions. So if you could, I'll call your name, and if you could just state your name and what organization you represent and what your role is there, that would be great. So again, I'm Colleen Shaw. I'm the Outreach Manager at Bloomington Public Library, and this is...
I'm Michelle Cope. I'm the Bloomington Public Library Outreach Library Associate and bookmobile driver.
Awesome. Thanks, Michelle. All right, Kat.
I'm Kat Hayes. I am the recovery specialist for the McLean County Recovery Oriented System of Care.
Thank you. Tommy.
Hey everyone, I'm Tommy Johnson. I am the Workforce Equity Initiative Success Navigator, long title, at Heartland Community College. I'm also the Black Student Union Advisor, and today is commencement, so congratulations to all Heartland students. So
Awesome. Thanks, Tommy. Corey.
Hi, everyone. I'm on the McLean County Board of Health, and I'm also on the Mental Health Advisory Board.
Thanks, Corey. Marita.
My name is Marita Landreth. I'm the interim director for McLean County's Behavioral Health Coordination Department.
Awesome. Thanks, Marita. Dell.
I'm Del Sam. I'm with the Veterans Treatment Court.
Great. Thanks, Del. Millicent.
I'm Millicent Bleesner. I'm here with Department of Corrections. I am what they call a corrections assessment specialist, and people in my role reach out to parolees and refer them to resources to reduce the recidivism rate.
Awesome. Thank you for being here. Elise?
Hi, my name is Elise Stewart. I have the same job as Millicent, but my county that I oversee, one of them is McLean County.
Great. Thanks, Elise.
Mhm.
Kara? No, we'll move on. Toy is on the road right now. I don't know if he's able to introduce himself or not. So
Hi, everybody.
Great.
Hello, everybody. My name is Toy Beasley. Like Colleen said, I'm part of the McLean County Reentry Council, and I also work for an agency called TAS, Treatment Alternatives for Safer Communities. I'm the Reentry Support Coordinator statewide, and I'm also a person that have been justice impacted. Excited to be here today, and I'm excited about hearing this great information.
Thanks, Toy. Sarah? All right, Nadine?
My name's Nadine Corey. I'm with the McLean County Health Department as the behavioral health specialist.
Great, thank you. And I'm sorry, I forgot, Sarah mentioned she's driving today, so she's just listening in. Jacqueline?
I'm Jackie Mathias. I'm the Inmate Services Director at the jail.
Great, thanks for being here. Langston? Langston's moving right now. He's on the job, so he might chime in later. Oh,
actually, I'm here.
Langston.
My name is Langston. I'm a board member of the McLean County Reentry Council. Like Toy, I'm also justice impacted. I've been to the county jail here in McLean County. I have been to state prison here in the state of Illinois, and also United States Penitentiary. I served time in. I'm now a business owner and entrepreneur and a real estate investor in McLean County, and I'm excited. Thank you guys for being here.
Great, thanks, Langston. Tim?
Oh, hey, I just joined. Sorry about that. I'm still getting set up a little bit. How are you?
Oh, that's okay.
Great. I was at your little event a week ago Saturday, and it was very good. I just got out of prison in November. I served 4 years in federal prison. So I don't need to share my whole story, but it was a very odd case. I'm a former multimillionaire, and built several companies, and one of them had a bad business loan, and I was offered 2 different plea deals. I rejected them. I famously told the prosecutor I'll go to prison before I plead to something I didn't do, and I lost the trial, and there I went. I spent 4 years, and I was released in November. I'm on home confinement, but I'm out a lot. I work a lot, and I'll be done with the sentence and start my supervised release on July 8th.
Oh, wow, coming up.
Great.
Thanks for being here, Tim. We appreciate it.
Thank you.
And Kara.
Hi, everyone. I'm Kara Alt, and I am the program director for the YWCA Labyrinth program. And I'm also on the board with the Reentry Council.
Thanks, Kara. All right, I think that's everyone. So thanks again for being here. I'm going to turn it over now to Mr. Scanlon, who's the trial court administrator, and he's going to be speaking to us on the Safety Act and its impact on the court system and doing an overview of that.
So I'm going to gloss over some of this. So if you have questions or it seems confusing to what your current understanding is, please let me know. Again, my name is William Scanlon. I'm the court administrator here in the 11th Circuit, which is McLean County and the surrounding counties. We have 21 judges spread out over those 5 counties and about 45 staff. So the Safety Act arises through a couple pieces of legislation. One of them, the Pretrial Fairness Act, the other, the Safety Act. They arise in about 2020 refined through the General Assembly and essentially do a couple of things, one of which I'll talk about today. They introduced cameras to all law enforcement agencies on a schedule. So cameras in cars were very common, but now officers must have body cams. And depending on the size of the agency, they have a different implementation schedule. But by 2025, all agencies should have officers with body cams who are out in the field. The second major thing it did, it eliminated the use of cash bail to the extent in the criminal justice system. There is an exception for the civil and family courts, but in the criminal justice system, they went to a provision of pretrial detention and evaluation of pretrial detention with conditions. So that was going to be effective January 1 of 23. It was challenged, the constitutionality of it was challenged. It was upheld in July of 23 by the Illinois Supreme Court and was effective September 18th of 2023. And Dr. Beck's data will start on prior to or after September 18th, 2023. The act sets forth, the Pretrial Fairness Act sets forth a number of standards in terms of offenses that are detainable and offenses that are not detainable. Some are automatically detainable, and some they have to make, the state has to present and the court has to make a finding that a person can be detained. The act sets forth standards for least restrictive environment and to hold someone, and whether or not they have a willful flight standard or a dangerousness standard, and that applies to a person or the community. So things that are automatically eligible for detention are things like first and second degree murder, aggravated robbery, criminal sexual assault, kidnapping, but also things such as stalking, violation of orders of protection, domestic battery, all sex offenses, and there's a number of miscellaneous offenses, but they're all serious felonies. Discharge of a firearm, unlawful sale or delivery of a firearm, sex trafficking, just a lot. There are a lot of statutes that are subject to an automatic detention consideration. Everything else is when someone is arrested, they have 48 hours to appear in what used to be referred to as bond court, is now referred to as detention court. And there's a process. The state has to file a petition for detention, or they can elect not to file a petition for detention. When someone is released, there are some mandatory conditions of release that can be placed upon them, such as which you wouldn't think would have to be placed upon them, but appear for every court appearance in the future, report change of address to the circuit clerk, violate no further laws of the state of Illinois, and stay within the state of Illinois unless given permission. So there are some pretty general ones, and then there can be some very specific ones. A lot of them you would be familiar with in terms of no contact with a residence or a person where there's an assault or domestic battery, no contact with a business in case there's been a robbery or retail theft. So every day, as there was 6 days a week, Monday through Saturday, there is a detention procedure. It's heavier on Monday because there's more arrests on Friday and Saturday, and it's lighter on Thursdays and Fridays because there are fewer arrests during the week. The state has a large role in arguing for detention or determining they're not going to file a petition for detention. And then court has to take into consideration a lot of factors in terms of what the information the state's presented, previous failure to appear, previous offenses, and the conduct of the defendant for the matter they were arrested on. So there's a lot of things for the court or a judge to consider. There's a lot of things for the state's attorney's office to consider when they're filing a petition. And then the defendant has a right to speak to counsel, and it's defined under statute as a meaningful right for them to speak to counsel prior to their appearance in detention court. So there's a lot of moving parts for someone who is arrested when they are booked into the jail. On one track, the state's attorney's office is reviewing the reports and then determining whether they want to file petition to detain. And on another track is the public defender's office has to get in, meet with these defendants, have a conversation with them in case there's a petition to detain. And then all of it comes together at court at 1:30 every day. So that's generally it. I'm going to turn it over to Dr. Beck for him to review some preliminary statistics. We have been, if we look at September 18th as the starting date, on what would that be? That would be February 18th. We've been, or not February, March 18th. We've been doing this for 6 months. Realistically, it took a couple weeks to process persons that were in the jail under these new standards and look at the jail population as a whole. So let's look at this starting on, for the purposes of discussion, October 1 to April 1, and look at those statistics. But Dr. Beck, I'll turn it over to you.
Before that, I was going to ask if anybody had questions on anything you spoke on. Should we hold them all to the end? Hold all the questions.
Whenever, I don't want to miss somebody who has to go, or some point I made. So I want to make sure we answer them. So we'll take them at any time. Really.
Okay. Yeah. If anybody has any questions on that overview before we get into Dr. Beck's presentation.
So I have a quick question. It sounds to me like it's very similar to the federal process. I've been to federal prison, and I had a bond hearing, and I couldn't pay money to get out. I went through a very similar process to what he just explained. I had to prove I wasn't a flight risk. I had to prove, these things, and then the judge decided whether I was a risk to the community and would be allowed to go home and fight my case, or stay in the county jail and fight my case from. Do you know, am I right?
It is very similar to the federal system. Like I said, great point. While Illinois is the first state to do this, the federal system switched over from a non-bail system to a detention determination in something like 1981. Yes, this is very similar to the federal system. There's a couple of small details. The federal system only has felonies. They don't have misdemeanors. And we have a lot more probably civil warrants than the federal system does. But he does make a very, very good point. It's very similar to the current federal system.
Mm-hmm.
Thank you for clearing that up. So it really, in my instance, it didn't work in my favor. There was some information that the only breakdown that I saw in it is they didn't have much time to prepare. So the prosecutors kind of got up there and just kind of said what they said. Some of the information was not true. And my attorney, who I had just met 30 minutes ago, who was just handed my name and my information, he had nothing and no information to rebuttal what was being said by the prosecutor. The judge ran with what they said, and I had to sit in county jail for 17 months fighting a marijuana case. So this works. It works, and it doesn't work. So I was just curious, was it the same?
He does, Langston, you continue to make excellent points. There are a lot of time limitations. There is a federal case, again, from 1989 or 87 called Riverside versus California, where they talk about a person arrested being seen in 48 hours. And that's a running clock from the moment of arrest. They have to have a probable cause determination. You have to make a determination about continued detention. And all that has to occur in 48 hours. If you're arrested at 2 a.m. on a Saturday night, and you know, we do have more arrests from Thursday night to Saturday night, Sunday morning sometime. That clock runs for a while because we're not sufficiently staffed to have public defenders available 24 hours a day, 7 days a week, or prosecutors. So the clock does run while the person is in detention, and that determination has to be made. There is a provision within the Illinois statute that requires a reconsideration of that detention determination, whether the person is going to stay in jail every time they appear. And so if you're arrested on a felony, let's say you were arrested on this last Monday, you should have appeared on Tuesday or at latest Wednesday. And your next appearance is likely to be in about 10, 11 days on the following Friday for arraignment. And then you're going to appear about every 30 to 45 days from that point forward, as our court is currently organized. This is for a felony case. At all those appearances, you will have an attorney, but at all those appearances, unless you elect to represent yourself, at all those appearances, the court has to make a redetermination of whether detention continues to be appropriate, or if the release conditions are sufficient. So that all occurs at every hearing. So.
Thank you.
Yep.
Any other? Yeah, go ahead if you have another question.
No, I was just going to say, I think Dr. Beck can share with us his research or preliminary research.
Sounds great.
Hi, folks. Thanks for what you do. Can I share my screen, Colleen?
Yes.
Okay.
You should be able to now.
Okay, can everybody see some slides? Okay. We'll just roll like that. Okay, so for some time I'm a faculty member at ISU, and for some time me and my students that I work with, we have been the data management arm for the county, where we look at the original issue was to look at the jail population and watch how the jail population changes over time, but that's morphed into a lot of other things. I'm working with Merida for an assessment of Fuse, and there's a host of other things we do. And so one of the things that's come up is the bail reform law and how it affects the jail population. And so what you're going to see today is a series of slides that show the jail population from January 1 of 2023 all the way through March 31st of 24. And so why that much time? Because we gave it a year up until the vertical line you see is September 18th, when the bail reform went live, and then what has happened since with the jail population. And for those who don't know, the jail population overall, it used to run 220, 240 and on any given day, and now it's hovering at 180, 170, sometimes 160. That's where the jail population is presently. And as Will explained, the change from the law was that those persons who are arrested on non-detainable offenses should not be detained. And so they are, it's my understanding, I'm not in the field doing this, but someone can be given a ticket and a notice to appear rather than go to the jail at all. Some folks can go to the jail and they go through a booking process and they're back out the door within an hour because it's a non-detainable offense. And Will, if I get any of this wrong, chime in.
Okay.
Those folks who are arrested on a more serious violation, be it a violent felony, be it a weapons charge, or be it domestic violence, and there are domestic violence charges that are misdemeanors, so keep that in mind. But it's folks who are being detained who someone, because of the arrest, the alleged offense, someone is saying that there's a risk to the community, and so that's why they're being detained. And tons of arguments all around that. What you're seeing on the slide in front of you is the jail population for non-detainable offenses on any given day. And so the vertical line is again September 18th of 2023. And you'll see that the blue line is bouncing around the number 80, horizontal line of number 80. So on any given day, there were about 80 persons in the jail. That means they were booked, and then they're likely not staying a night, that are booked and then released within a period of time that the court decides. And Will is saying it could be 48 hours, it could be less, and so that's where it was before September 18th. And after September 18th, the vertical line again, you see that the number, the blue line is bouncing around 60. And so on average, from 80, an 80 number in the jail on non-detainable offenses to 60 persons in the jail on non-detainable offenses, it turns out it's a 27% drop. So by comparing the average before September 18th to the average after September 18th, we're looking at a jail population for non-detainable offenses is down 27%. Yeah. This looks at looks at the numbers by detainable charges. So looks at the jail population by detainable charges, again by day, from January 1st of 23 all the way to March 31st of 24. Again, the vertical line is September 18th. And it looks at violent offenses, it looks at weapons offenses and domestic violence. And I think that this shows, well, I'm not going to get in the, I don't know enough to say that this is saying that some law is working. I don't know enough to do that. What I can say is that violent felonies are down. And are they down overall in the jail because violent felonies are down? Sure. Yes. Also down because people are not being held as long as they were before. And domestic violence, the gray line, that's up. And before bail reform went into effect, everybody told me that that was going to happen. Why would that happen? Because domestic violence is often a misdemeanor offense and someone could have bonded out. And now domestic violence might be a reason to be held, and someone cannot bond out. And so DVs here in this chart are up 23% compared 23% post bail reform compared to what it was pre bail reform. So domestic violence present in the jail is up, and gun charges are down 21%. So overall, the violent offenses, gun offenses down, DVs up, because of the changes to the law and how people, bail reform, pretrial fairness, safety, whatever you want to call it. This looks at class 4 felonies and misdemeanor offenses in the same way. Why do that? Because the cross between what's a misdemeanor and what's a class 4, you know, what's a felony versus what's a misdemeanor. Those are, Will may disagree with me, but those are in some ways, the criminal offense of a felony is most proximate to misdemeanors when it's a class 4. That's what
Correct. I would agree with that.
And again, both are down, but misdemeanors are down 40% from where they were before the Pretrial Fairness Act. So you'll see that misdemeanors, the number there is bouncing between 5 and 10 and above 10, sometimes as high as 20 in the jail. And after bail reform, misdemeanors, the number in the jail is bouncing at around 5 misdemeanors in the jail on any given day. And so that just says that those persons who are arrested on misdemeanors and before bail reform, they would have had to post bail in order to get out. Now they, unless it's a domestic violence misdemeanor, folks are getting out quicker. And we can even measure how long folks are in the jail by hours and minutes. It's amazing how much, you know, when folks who are on this call who've been in the justice system, they know that everything is public. And so all the data are there. Okay, so that's that. This looks at murder and class X. According to the state's attorney that I talked to for our county, the murders are up just because murders are up, because in the past they would have been detained anyway, and up by a few. So it's not a huge change. And then the class X, again, because of bail reform, that's down 23% compared to what it was before bail reform. And then here's race. So the Latinx population, Hispanic population has seen an uptick in number of persons in the jail on any given day after bail reform. It's up 43%. That's a big percentage jump. That mathematically that would be affected by the numbers being so low before. I haven't looked any further as to why that number has gone up the way it has, but the jail population of African Americans, is the blue line, is down 15% post bail reform, and down 23% for the white population post bail reform. So given the alleged offenses that folks have engaged in, the white population has dropped more than the population of persons of color in the jail. So that's something that the data are making at least me aware of, that overall it's the white population that's experienced the most change. Again, that could be, and I would say probably most likely, related to the alleged offenses. Here's it is for sex, and you can see that for both men and women, it's about the same drop. It's about 15%. It's 15% for men, 13% for women in terms of the number of persons in the jail. So what's happening next? Back to this one. I'm looking forward. Well, that's a strange thing to say. As we approach September 1 of 2024, we will have a year of arrest booking information, jail population numbers, pre-bail reform and post-bail reform. And we're even looking at changing these graphs, of which are just the jail population numbers, looking at it in a way of rearrest rate. So what was the rate of people being rearrested pre-bail reform versus what's the rate after bail reform? And if you think about that for a couple minutes, that's one of the key questions of whether this bail reform law is actually a good or a bad idea. Because there's plenty of folks saying that this is a lousy idea because folks are going to be out sooner than they were before under the bail system. Well, I don't know what the numbers are going to show, but it could show that rearrest is no different. The system doesn't the new arrangement doesn't necessarily mean that persons are out who shouldn't be. So we'll see what the numbers show. And that's what I have to share today. I'm willing to take any questions.
Well, let me add real quick, the research being done about rearrest rate is our local research is mirroring a larger effort by Loyola University, who is gathering data from, I want to say, 16 counties spread across the state of Illinois, various sizes, but includes Cook County, to determine what the rearrest rate is for persons under the new system.
Yes.
I have a real quick question. Is there any way possible that some of these charts, the change in them could be affected by the decriminalization of marijuana as well? I would imagine a lot of arrests, were from that and the decriminalization of marijuana. I'm probably aware that happened before the no cash bail. But could that have any effect on it?
Yes. And Will, you're going to have to help me with when the cannabis law changed. 2018, 2019?
It was in September of 2017, actually, went into effect. And yeah, we look at it as probably January 1 of 2018, realistically, by the time it all came down. Now, that really had a major impact as we've looked at it on misdemeanor arrests, to an extent, with a caveat, but I'll get to that. You can only possess 30 grams, 1 ounce of marijuana, and so the misdemeanor arrests went down. Unfortunately, we have a considerable population with the universities of persons, and you have to be over the age of 21, I might add. We have a considerable population with the universities under the age of 21, so we continue to have a number of both misdemeanor and ordinance violation arrests for possession of marijuana, but it is all geared toward persons under the age of 21. Which is any amount is illegal. Same with alcohol. But so we still have those arrests. That arrest rate probably ticked up quite a bit because of the availability of cannabis in the community, legal cannabis in the community.
Sure.
But for that population, they're barred from. I was 21 once. I was 19 once. It's just a matter of they don't think they're going to get caught. So the marijuana issue has an impact, but the largest portion of that impact was on marijuana arrests, which were not being held in the jail for very long. The felony arrests have for marijuana have stayed pretty consistent.
Another quick question, source bond hearings. So for like someone for the manufacturing and delivery, right?
Right.
And they have a bond hearing before they would set a bond, and then you would have to have a separate hearing to prove like where the money came from that you're bonding out with.
Correct.
Would source bond hearings still be a part of the process for the no cash bail?
They are, since there is no bail, no
Right.
felony or misdemeanor has bail any longer,
So
no financial matter, there are no source bond hearings.
Gotcha. Okay.
Okay,
That makes
so
sense.
well, with one exception. So I will say briefly, there are still warrants with cash bonds, but they're confined to family and civil cases
Gotcha.
because the Pretrial Fairness Act only applied to criminal matters and traffic matters. It did not apply. So if you are overdue $10,000 in child support and refuse to come to court, you are going to have a warrant with a cash bond. So there will be persons who are being held on warrants with cash bonds, but if you look underneath in terms of what the charge is, it's I would gather that 99.9% of them are civil or family warrants where they are under a contempt of court citation.
And that makes a lot of sense. Just so people listening understand, there's usually some money attached to that violation. And even in civil court, usually your bond, you didn't used to get 10% of whatever your bond was set. Whatever your bond was set, you had to pay it in full because it went towards whatever that civil matter was, the child support, the whatever. So people had to pay that to get out. And so that makes a lot of sense that that's still in place.
That is correct. All of that is correct.
Great. It looks like Tommy has a question.
Sure. I do. So like, I'm hearing this. So I'm trying to understand like the domestic violence one. So even misdemeanors, you can be detained for a while. I guess like what is like they cannot be released once
they cannot be released until because there is a requirement. There's there's like a 3-step requirement. For the state, they are required to file a petition to detain, or in the absence of detention, if they want to impose conditions of release. Even if they're going to be released, if in order to have conditions imposed, they need to have that hearing. So persons have to be detained until they can have that hearing. They can't agree up front. The jail or the law enforcement agency cannot negotiate those conditions of release with the defendant. It can only happen in open court. The second thing is the defendant has to have consultation, or at least time to consult with counsel prior to that hearing. So it cannot occur at the time of arrest, even if the state knew that their only condition of release was do not return to the place where the domestic battery occurred and do not come in contact with the victim. Even if that could be established the minute after they were arrested, the defendant has the right and requirement under the law to have consultation with counsel. And so domestic violence cases are held about the same amount of time as they used to be, but it is for the purpose of placing those conditions on them and meeting the requirement under the law that they have counsel, have the opportunity to speak to counsel.
So that's just like, doesn't matter, right? Misdemeanor, felony, it's all the same.
Yeah, in both instances, that requirement is in place.
Okay, thank you.
There were a couple of questions in the chat. I took a quick look. I think Kat was asking, are these is this all the data, or is this data on certain charges, or is this data on certain people or so forth? This is all of it, Kat. So the county places data into a secure place. I reach in and grab it the first of each month, and it's all of the data I'm allowed to see. For instance, I don't see names. I don't see, they won't let me see date of birth, because I could figure out who is who. So I don't know the people behind all of this, but I know race, I know sex, not necessarily gender, if you know what I mean, and year of birth, and then it's all the offenses. It's everything. And then I think Marita asked whether the number, or how would the numbers that I showed on race, how that would compare to the census. I think, Marita, it in other presentations over time, we have a way disproportionate amount of African Americans in the jail relative to the census numbers. So persons of color are 48%, 47% of the jail population, but they're making up 15% of our county. So yes, things are disproportionate.
Well, theoretically, like part of the role of this law was to even that out a little bit. That it was theorizing that because of the reasons, redlining, systemic racism, all that stuff, that non-white folks are less likely to have the money to put forward bail. And so if we got rid of that, I wonder, theoretically, over time, if it's doing what we're hoping it does, is that there should be some kind of change to that. Because I'm definitely expecting a disproportionate ratio, but I wonder if over time, hopefully over time, that will decrease.
Right. Yes. Hopefully over time that would decrease. And I can tell you that I'm keeping my eye on it for my own research project. For instance, I can tell you that once you hold constant, and I don't want to make everybody's eyes glaze over, once you take into account the charges that some have been filed against somebody and a bunch of the legal matters, African Americans are spending in the jail half again as long as the white population, so 50% longer after you take into account everything else. And I've shared that information with the CJCC before. That's all pre-bail reform. And so what you're raising is the possibility that the bail reform will cause that 50% longer to decrease, because because ability to pay bond has been taken out of the equation. So that's possible.
I have one more quick question. I would imagine some people don't have to come up with much of an argument, right, to get their case just is non-detainable. But what if they are looking at jail time? Do you have the ability to say, you know what, I don't want to do all of this pretrial stuff. I would rather just stay in jail. My time is running now. Do you have the ability to say that, or do they just say this is non-detainable, you have to go?
The PFA, the Pretrial Fairness Act, is kind of that used to be a practice for persons who thought, well, if I'm convicted, I want to do a majority of my time locally, so I will do what is called what we used to refer to as surrender on bond on this case. That would, if you were facing a very serious felony, you knew, and a less serious felony, you could mitigate the time you spend on the less serious felony by surrendering on bond. The Pretrial Fairness Act, and I think this wasn't a conscious decision by the legislature in any part, prevents the sheriff, the state, the court from holding someone on a non-detainable offense for any time. You cannot surrender on a non-detainable offense any longer. So if an offense is probationable and you're not going to be detained, you can't say, well, just in case I'm convicted and I get sentenced to 180 days, I want to do those 180 days now. That is not a possibility. If it's a non-detainable offense, or even if it's a detainable offense, but the state elects to not file a petition to detain, a person cannot be detained on that offense, regardless of what their decision is.
Thank you. Any other questions?
I just wanted to ask, I noticed that the graph seemed to be eking back up there at the end. Is there any concern going forward that that's going to just continue?
Summertime.
Yeah. Will, you're chiming in and you're saying it's summertime?
No, that was Langston, but he's
That was
right.
me.
We do see a seasonal change in the jail population. We see a seasonal change from May to about September, where we have a higher jail population. That was prior to the bail reform. I suspect it's going to continue, just because when it's snowing, we don't have as much crime in the neighborhood. So, but all kidding aside, we do have a seasonal variation in the jail. We have fewer persons, even though we have a large influx of the of a younger population with college. We do see more arrests from May to September, just because the weather drives people outside. There's more, I don't know how to better explain it, than there's more opportunity for persons to engage in criminal behavior, I guess.
Mm-hmm. My other question is, how have the judges responded to this? I mean, are they in favor? Has it worked? Have they considered it to be working well? How's it working for them? Do they feel comfortable doing what they're doing?
Mm-hmm.
Well, one of the major changes was, bond court used to take about 45 minutes, an hour and a half on a long day.
Mm-hmm.
This change over to having hearings for detention and conditions of release has really lengthened that period of time. We've had to devote half of a judicial position just to this process, whereas we used to just have it, as part of 4 or 5 persons would come in and do it as part of their other duties. So it has affected the court schedule to that extent. It also has tied up the state's attorney and public defender as well. As in terms of working, I think that's really an open question. I mean, it's without drilling down to an individual case, certainly the concern is generally that someone is going to commit additional offenses or more serious offenses when on release. And that can be addressed, but only after those offenses. So the open question is, under this new system, are persons committing more additional offenses while on release? And if so, the open question is how to address that behavior, because the offenses in question that led to them not being detained are going to remain non-detainable offenses, generally in a kind of universal sense. So how do we consider more supervision through the pretrial supervision unit of probation? Do we consider other conditions other than supervision? Is there other programming? So we have to understand both the nature of the subsequent offenses and the resources that are available to address those. But yeah, that from the court's standpoint, I think everyone knew this was going to take longer. I don't think anyone anticipated quite half a day every day as being the ask. And sometimes Jackie Matthias can speak to this. I mean, sometimes it's 5 hours. Sometimes they're there till 5:30, 6 o'clock at night. Whereas, you know, previously 2 o'clock in the afternoon would have been a lengthy proceeding. So, you know, particularly Mondays, Tuesdays after 3-day holidays, you're talking about 4 or 5 hours of people in court, and it ties them up. I mean, if you're waiting for your hearing and you're going to be released, but you're 12th on the list, you're going to be there for another 5 hours. So and there's really no getting around that. We, you know, people are getting an opportunity to have a full-blown hearing, even call witnesses as necessary. So that, I think the first couple months, it was kind of a, from an internal standpoint, kind of a rude awakening of everybody kind of thought, yeah, we'll find a way to make this go faster. And there's no way to make it go faster. It's just the process. And you have to walk through the process. And yeah, the other half of that is, how's it working? I think that's where the research lies.
Yeah, right.
And sorry, last question. I really want this to work. I want for people not to have to pay cash bail. But are they getting the services that they need as far as psych evaluation, things like that, that they don't have the time in the jail? Is that being missed?
We still have the ability to have people who need fitness exams be ordered for fitness exams, even if they're not in custody. So now the availability of follow-up services is still limited. You know, there is new programming opening, but there are still limitations in this community, well, almost every community, in terms of programming that's available. Particularly those persons without insurance or who are not in custody. Kat asks, does it tie into drug and the recovery court, treatment courts clients? I think to a lesser extent, it's affected the specialty courts. They have a very specific, all of those are post disposition, post conviction, as it were, models. And so identifying those persons is still a process that's done through a variety of resources and assessments. Public defender, the jail is a huge focal point for identifying persons who may be eligible, but it really comes down to getting to a disposition to get them into the program for all the veterans, the recovery mental health court, and the drug court. So it has not impacted that court that I'm aware of. Those courts that I'm aware of substantially, but
so what I'm hearing is like things like mental health evaluations, substance abuse treatment evaluations, those can still be court ordered as a stipulation of pretrial release for a non-detainable offense. So if we looked at a chart at like Chestnut, it's probably going up the other way in attendance and those types of things, because now people aren't just sitting in jail. They can actually go and be on pretrial release, start the things like evaluations and stuff like that. You know, so their charts are probably going the other way.
Yeah, if those resources are available to them, they should have greater flexibility in attending.
One other question I have is these funds that come from people paying bond. I never really knew where my bond money was going, but where it was being allocated to. where does that burden fall now? Like bond money had to be supporting something for the county, for the jail, something. Where does all that money now come from?
All that money is now coming from the general fund.
So taxpayers.
Yeah, there isn't any, I'm not aware that we have increased any fees to offset the loss of the bond funds.
Is there any statistics on how much money was generated annually in bond money?
I think the clerk's office had a report on what they generated, and the sheriff's office had data on how much they collected through the bond fund. So I don't have those numbers off the top of my head. From the clerk's office standpoint, you know, they were receiving 10% of every dollar that was posted as bond. And so that was a considerable source of revenue for that office.
That's a big chunk of money.
Yeah, there's a big chunk of money. All that has had to either be absorbed by the general fund or is being offset. They still have a document storage and court automation fund that are part of your assessment when you are convicted. Not you, but you generally when a person is convicted. And so some of that couldn't be offset through those funds, but the rest of it had to come through the general fund.
Okay, well, we are just past the 2 o'clock hour now, so we're getting ready to wrap up here. Again, I want to thank you, Mr. Scanlon, for coming in and speaking to us. I'm sorry Judge Yoder couldn't be here, but I really appreciate the information that you were able to provide for us. And also, Dr. Beck, your research is much appreciated. We're very thankful that you both could come to speak to us today. If you, everybody, so you know, this is being recorded and we're going to post it to our YouTube channel. So if you have a colleague that wasn't able to attend, please know that that will be posted within the next few days, and we will share the link. It's McLean County Reentry Council. You can look it up on YouTube, or we'll share the link on our Facebook page. So thank you again for everybody for attending, and I hope you have a wonderful rest of your Friday.
Thank you very much for having us.
Thank you so much.
Thanks for being here, guys.
Bye.
Thank you.
Appreciate it.
Bye-bye.
Bye.
Thanks, Colleen.
Yes. Should I stop the recording? So I hit stop.